Every legal system faces a fundamental tension when dealing with mental health. Where does an individual's right to personal liberty and self determination end, and where does the state's duty to step in and protect life begin? When a person experiences a severe mental health crisis, should the law treat them as an autonomous individual with full authority over their body and choices, or should it view them as a vulnerable citizen requiring paternalistic state protection? In Malaysia, this delicate balance is governed primarily by the Mental Health Act 2005 or Act 615, its subsidiary Mental Health Regulations 2010, and the landmark 2003 legislative amendments. So today, we will be examining a central question. To what extent does Malaysia's mental health legal framework strikes an appropriate balance between protecting individuals' autonomy and also enabling state intervention? To answer this, we must state our central position clearly. Malaysia's mental health legal framework remains paternalistic and state-centric. While the statutory structure provides swift mechanisms for public safety and emergency clinical care, it disproportionately favors state intervention over individual autonomy and dignity. The balance leans heavily toward medical paternalism due to three key structural features: a purely medicalized pathway for involuntary detention operating outside court oversight, broad coercive entry and apprehension powers granted to non-medical enforcement authorities, and also oversight structures such as the Board of Visitors still remain tied to the executive branch rather than functioning as the independent judicial tribunals. Under Section 10, a person suspected of having a mental disorder can be involuntarily admitted to a psychiatric hospital without prior judicial authorization. The process requires an application by a relative using Form 3 and a recommendation by a registered medical practitioner using Form 4. Once admitted, the individual is evaluated within 24 hours. If continued detention is deemed necessary, the medical director of the hospital can order hospitalization for up to 1 month. To extend detention up to 3 months, two medical officers, one of whom must be a psychiatrist, must examine the patient and issue an order. Notice the threshold. Admission is justified if detention is required in the interest of his own health or safety with a view to the protection of other persons. When we turn to treatment, the law reveals a striking contradiction regarding consent. For special treatments like electroconvulsive therapy, surgery, or clinical trials, the Act sets out to a capacity-based framework. If the patient is competent, they must consent. If incompetent, consent falls to a relative or guardian, or to two independent psychiatrists if no relative is traceable. However, for conventional treatments such as standard psychotropic medication, the Act explicitly states that no consent is required. This means an involuntarily admitted patient, even if mentally competent to understand their treatment, loses the legal right to refuse daily psychotropic drugs. This statutory exemption directly overrides the common law doctrine of bodily integrity. In 2023, Malaysia took a monumental step by decriminalizing attempted suicide through the repeal of Section 309 of the Penal Code. However, as part of this legislative overhaul, Parliament passed the Mental Health Amendment Act 2003, significantly expanding state interventions through Community Intervention Officers or CIOs. Under Section 11 Sub 5, the definition of a CIO was broadened to include a non-medical personnel, police officers, officers of the Malaysian Maritime Enforcement Agency, firefighters, auxiliary firefighters, civil defense forces, and community welfare officers. Under Section 11 Sub 2, CIOs are granted sweeping powers. A CIO may apprehend anyone they believe to be mentally disordered and dangerous to themselves, others, or property, or anyone attempting suicide. To carry out this apprehension, the amendment grants CIOs the statutory power to forcibly enter any premises at any time, including breaking down doors and windows or forcibly removing any obstructions. While intended to save lives during acute crises, this also raises a serious legal concern. There is risk of trauma and escalation. Granting forcible entry powers to non-medical personnel without mandatory specialized psychiatric crisis training risks criminalizing mental health crises. There's also impact on healthcare ethics. If a medical practitioner are drawn into enforcement operation alongside the CIO, it creates conflict with doctor-patient confidentiality under Section 30 of the Medical Act 1971, and it undermines therapeutic trust. The case that we can refer to is the case of Wong Sao Kian and Wong Gawa. It was held that committees appointed for mentally incapacitated persons must demonstrate objective, workable plans and maintain internal harmony to serve the patient's best interests. Under the Mental Health Act 2001, consent plays an important role when it comes to the treatment of mentally disordered persons. For procedures such as surgery, formal consent is generally required. This consent may be given by a competent patient, guardian, or relative depending on the circumstances. However, the Act makes an important distinction for conventional treatments. In cases involving involuntary admission, a competent adult cannot simply refuse standard medication or conventional treatment merely because they are being treated against their will. In the case of Fu Fiona and Doctor Su Fuk Moon, the federal court emphasized the importance of informed consent. Doctors have a duty to provide patients with sufficient information about the material risks of a proposed treatment so that patients can make an informed decision. This case therefore highlights the principle of patient autonomy. Patients should be given the information necessary to decide whether they want to proceed with the treatment. The Mental Health Act 2001 also requires medical directors to display and provide patients with a statement of their rights. The Act also protects important rights such as confidentiality with informed consent, where applicable. This is important because being diagnosed with a mental disorder does not mean that a person automatically loses all control over their medical decision. In Gary Lim Ting Hao and Lim Pang Cheong 2015, the medical report stated that the subject had dementia. However, surveillance evidence showed him carrying out everyday activities, such as buying groceries, purchasing fuel, and playing golf. The court therefore recognized that a medical diagnosis alone does not automatically mean that a person lacks legal capacity. Ultimately, the case reinforces the patient autonomy by showing that a person's actual capacity must be properly assessed rather than simply assumed from a diagnosis. Malaysia ratified the UN Convention on the Rights of Persons with Disabilities in 2010. When we compare Act 615 against key CRPD articles, significant gaps emerge. Article 12 of the CRPD advocates for a complete shift from substituted decision-making to support decision-making. Malaysia's Act 615 relies almost entirely on substituted decision-making through relative, guardians, and appointed committees. Malaysia also lacks a statutory framework for advanced healthcare directives, preventing individuals from issuing binding instructions for their care during periods of wellness. In Article 14 of the CRPD, it establishes that the existence of a disability or mental condition can never justify deprivation of liberty. Section 10 of this Act 615 directly conflicts with this principle by permitting involuntary detention based on psychiatric diagnosis and risk assessment, while Article 25 of the CRPD guarantees that healthcare must be provided based on free and informed consent. Act 615's exemption for non-consensual conventional treatment violates this standard. Furthermore, in jurisdictions like the United Kingdom, under the Mental Health Act, involuntary admission requires recommendation from two doctors and an approved mental health professional, ensuring a social perspective is included alongside clinical judgment. Furthermore, UK patients can appeal their detention directly to an independent mental health tribunal chaired by a judge with access to statutory independent mental health advocates. In Australia, such as under the Victoria Mental Health and Wellbeing Act, The law explicitly codifies supported decision making principles and legally recognizes advance statements. Reviews are conducted by an independent mental health review tribunal. In contrast, Malaysia remains reliant on executive appointed boards of visitors, substituted decision making, and non consensual treatment exemptions. When the state deprives a citizen of their liberty on medical grounds, what safeguards exist to prevent abuse? Act 615 establishes two main administrative legal mechanisms. First, the Board of Visitors appointed by the Minister of Health for each psychiatric facility. A board consists of at least three members, including a non hospital medical practitioner and at least one woman. The board inspects facilities, investigate complaints, and can order a patient's discharge or extend detention for up to 12 months. However, the Board of Visitors suffers from a structural flaw, a lack of institutional independence. Because members are appointed by the Minister of Health, the executive authority operating public hospitals, the board functions as an administrative agency rather than an independent judicial watchdog. Furthermore, mandatory patient reviews occur only once every 12 months, leaving long gaps without independent scrutiny. Second, judicial supervision under Section 52. A relative or public officer can apply to the High Court to conduct an inquiry into whether an individual is incapable of managing themselves and their estate due to a mental disorder. To conclude, does the legal framework governing mental health in Malaysia strike an appropriate balance between individual autonomy and state intervention? The answer is no. The current framework remains disproportionately weighted towards state intervention and medical paternalism. While statutory mechanism allows rapid response during crises, they treat the patient primarily as an object of protection or risk management rather than a holder of fundamental rights. Malaysia should also pursue several reforms in order to make it compliant with statutory framework. First, to ensure that all community intervention officers designated under Section 11 receive mandatory specialization psychiatric de-escalation training to prevent the criminalization of mental health crises. Furthermore, to also repeal the statutory exemption allowing non-consensual conventional treatment for involuntary admitted patients who retain decision-making capacity. Only by enacting these reforms can Malaysia bridge the gap between state protection and individual autonomy, ensuring that mental health care is delivered with safety, justice, and human dignity. That is all from me today. Thank you.